So first of all, I'll make a few remarks. Then I will speak about what is legal history, what is legal history for, why should legal history be included in the curricula of law school, new perspectives in legal history, and some final considerations. In recent years, the inclusion of legal history in law schools curriculum has been a battle that legal historians have had to face because legal history has been eliminated, cut, or its contents have been distributed among various subjects in many universities. But disciplines need to question their existence, to revisit concepts, to exit from the comfort zones, to change their approaches. Why? Because of changes, because new sources appear. And what is the purpose of this presentation? It is to discuss once again on the role of legal history in the education of law graduates. So let's move to what is legal history. Legal history is a discipline that studies the development of law over time. It studies the changing relationship between law and society, and that aims to answer the question of how rules change and, above all, why. And legal history covers not only norms, but also customs and doctrine and acts that exist in a legal system, and also acts which, because they systematically violate a legal system, demonstrate the inadequacy of certain norms, and finally leads to its fall or abandonment or its reform or substitution. And let's move to what is legal history for? And the answer to this question is the historicity of law. Because law is a historical product, because the societies in which law is born, develops, and is applied are in constant change. Because law is mutable, and because we must escape from dogmatic perspective and banish the relief that the law of today is the law of always. The evolution of societies calls for new solutions. Legal history demonstrates the relativity of law as a consequence of its evolution. Legal history demonstrates changes that occur in relation to concepts and interpretation. Legal history contributes to the dynamic analysis of the legal order. Legal history leads to the understanding of a legal history. And basically, legal history provides current law with the social, political, economic, and cultural backgrounds that underlie societies that adopt particular legal system. And what happens with the neglect of legal history? The neglect of legal history leads to a fragmentary, incomplete, superficial, external knowledge of law. So why should legal history be included in the curriculum of law schools? First, we must speak about the myths about the inclusion of legal history in school of law school study plans. The myths are that legal history is only a formative discipline that lengthens students' cultural horizons. And for students, it is a backfilling subject. And what is the current situation in Argentina? In Argentina, legal history is a desirable content that should be eliminated from study plans or included as an elective subject, that it has been a subject that has been left on the side because the emphasis, the focus is placed on the exercise of the attorney's profession. And what is the consequence of this situation? That some contents of legal history have been distributed in other subjects, such as, for example, constitutional history, history of institutions, political law, and so on. Legal history has not been taught from legal history perspectives because those who teach legal history are not legal historians. So legal history should be part of the curriculum of law students. Why? For students to lay the foundations for understanding the institutions they will study in their future study plans. To train future jurists and not to train simply law operators. To prevent students from becoming specialists in fragmented compartments. Legal history provides students with a cultural background to be able to understand the world in which they live and in which they will develop their profession in the future. And it provides the methodological tools that will help them in their profession. And what is the situation connected with law graduates in Argentina? Law graduates in Argentina historically have been inserted in all fields. The majority of our presidents have been law graduates. Most legislators are law graduates. Law graduates are the future judges who decide how laws are interpreted and applied. Law graduates in Argentina are those who design the legal order. Therefore, today's students will be the future politician, judge, legislator. And how should we, professors, teach legal history? Professors should teach a useful and not a theoretical legal history. Professors should bring history closer to the daily life of students, should show them that legal history is education for the future and not only the past. So let's move to the new perspectives in legal history. The news is that war is not over and that new battles must be fought and that we need to face new perspective. One of these perspectives is comparative legal history. Law does not consist of compartments. The current legal systems are the result of linking of previous solutions. The study of law cannot be limited to a specific time, to a given space, an isolated object of study, because fragmented visions limit the study of the juridical phenomenon. So the emphasis should be placed in what may be shared in what can be compared reciprocally. The focus should be placed in the circulation of legal ideas and mentalities, in the normative models, in legal transplants. Comparisons in time and space give the benefits to help improve existing norms or those to be created in the future. We must also focus in the interdisciplinary dialogue with general historians and with experts in positive law. What for? For legal historians to correct the direction and purpose of their inquiries, and for dogmatic jurists to relativize law. So let's move to my final considerations. Legal history should be studied in order to understand the keys of interpretation and understanding of legal development from its most antecedent to the present day. Legal history should be studied in order to broaden the horizon of scientific knowledge, to understand our cultural framework, to understand the lines that lead to the transformation of our legal history. Legal history is necessary for students, for attorneys, for legislators, for judges, for politicians. And let me finish with a very interesting phase by a Brazilian legal historian, Valdemar Martins Ferreira. No one is able to take a step forward without leaving another foot in the rearguard. Thank you very much.